give you a roundup of what has been happening in the course of this year, and it's always a difficult choice. Okay, so this is what I regard as the most relevant decisions and pending cases of what happened between last June and now, and I won't cover all of them. Don't fear. But I did do a selection, and before I start out with it, I want to point out 2 or 3 things. I will first talk about what is left over from last year. What does that mean? There were some cases I mentioned that were pending last year that have been decided in the meanwhile, and then I will give you an overview of what is relevant that came from Luxembourg, and then what you might have to look out for in the next couple of months and year maybe, and then what about Strasbourg Court of Human Rights. And when I selected the cases, I did it according to how it links to the topics of this conference. So hopefully you will recognize, even to the very last presentation of Laurent, some connections to what you've heard in the last 1.5 days. It's a difficult choice every year on what to focus, mainly, especially because I could talk only about the Court of Human Rights all the time, but I actually focus on Luxembourg. Luxembourg meaning the Court of Justice of the European Union with its seat there, because we have both constitutional issues, but I put that in quotation mark, so fundamental decisions on how to deal with EU law that are relevant for us, but also simple interpretation of statutes, or more precisely regulations, directives, and so on. And Strasbourg is also fundamentally important, but it is usually fundamental rights, the interpretation of either Article 10, freedom of expression, or Article 8, privacy. And so the cases are maybe more along a specific line. An individual is unhappy, and this is the outcome, whereas the ones of the Court of Justice are a little bit more complex. Actually, in reality, we would also have to look at the most important developments on national court level, because they very often also have something to do with interpreting EU law, maybe also comparing, like we just heard in the competition law area. It's very important also to compare what at least the Supreme Courts do or the national authorities. We cannot cover that here. When I say media law update, I mean everything that is relevant for the development of media law or relevant for companies active in the media sector. That means we have media, traditional media, new media, but we have also intellectual property law a little bit, e-commerce law, data protection law, and also a telco case. I'm not going to go into depth of any of the cases simply because of the fact that we do not have the time to do that. So forgive if it's not an in-depth interpretation. I would rather want to highlight what has been happening and what do you need to look out for. In terms of frequency, you would think I can prepare this presentation sometime in May, and then I've got a couple of weeks to go. But as I explained to you yesterday, that's not what I do, because indeed at the moment we have a frequency which is amazing, both from Strasbourg, basically nearly every day, at least once a week there's an interesting Article 10 case in Strasbourg, and even from the Court of Justice of the European Union, as you heard several times now, we had an important case the day before yesterday. So, let's see, what are the leftovers from last year? There's one that was Persidera, that concerned a question which has been ongoing for a very, very long time. That's the assignment of radio frequencies for the digitalized transmission of signals. So basically television broadcasters that had used analog systems, the question was how would the switchover happen to digital? And at the time in Italy there was maybe an, let's say, diplomatically unhappy political constellation where the government's head, so the prime minister, also was very active in the media sector, and some of the companies that he owned profited from a switchover situation where there was basically frequencies allocated on the basis of who was already a relatively active market player. And the question was whether this was violating standards of EU law, and indeed the Commission investigated, said you can't do it like that. The law was amended, but nonetheless, even in the consequence of the amended law, there was an outcome which meant that some new market players had difficulties in being present sufficiently on the digital market, simply in terms of the technology offered to them. And one of the main competitors that had problems with that was Centro Europa 7, and they went forth to the Court of Justice on a different case that came to the CJEU, and they basically won the case that the Italians had assigned a license without the frequency, which was not according to the law, and they even, and that's more relevant, won in Strasbourg on a Article 10 case, and they got a huge compensation, except that in the meanwhile, Centro had already run into serious financial trouble. This new decision, which is of last July, so just shortly after our conference, is interesting because it reiterates that when you allocate frequencies, you have to do so on a non-discriminatory and proportionate manner, which means if it's not a mathematical transition, which was not possible because there were more numbers here than there, was less frequencies available, then at least you have to come up with a conversion criteria which is proportionate. And one aim that is legitimate in view of the Court of Justice is if you say the continuity of the TV output. So in other words, we want to ensure that even after the digital switchover, people get the same content that they are used to. That's okay, but it's not allowed to lead to a situation where they do not get any other new content, basically where other competitors have no chance. So although the measures or the criteria that were applied are okay in view of the Court of Justice, the outcome was not okay. They basically did a calculation error, and it was not okay to exclude many, many, many competitors who also wanted to have more chance, whereas the incumbent operators, they got too many frequencies in the digital market. Now you would say, is this still relevant today? 2017, 18, we've got a more, allocation or dissemination via IP and other forms. But still, I think this is a very important case because it gives us an indication that the infrastructure rules, the telecommunications rules, play out also for content providers. Next one is, that was shortly before being decided, Stichting Brain. Be careful, there's several of that Stichting because it's an association that takes care of IP rights against Ziggo. That was basically a classical situation, an internet service provider that has a lot of subscribers that use a very popular website, TPB, you know what that stands for? The Pirate Bay, indeed, one of the most popular websites for file sharing, which are mainly illegally uploaded there, the files. And so here we have the service provider who just gives access to his subscriber to this website. And the question is Ziggo also responsible in a way? Is it a communication to the public? I have started using this abbreviation like many others, CTTP, because you have so many cases in that. So is it a CTTP? If Ziggo itself does not actually put the files on the Pirate Bay, but only allows its subscribers to access. Well, in actual fact, Ziggo did a little bit more. They indexed and categorized. So in other words, if you went via the Ziggo website, you could quicker find what you were looking for on the Pirate Bay, where then indeed there were works that could be downloaded, which were protected and had not been cleared with a license. And the Court of Justice said, and this is really a very relevant decision, making available on the internet of a sharing platform which indexates metadata is to be regarded or can be, depending on the circumstances of the case, a communication to the public. So be careful, internet service providers, that you are not being too active in the indexing. So just a search engine, maybe not, but indexing, yes. What do we have on new developments from Luxembourg that I want to take care of? Well, obviously, because that was the major topic of yesterday, it's Audiovisual Media Services Directive. We do not have many cases concerning that directive, but there is one of this year, and that's a Peugeot case. I'm not going to run the video, it's only 15 seconds, but some of you maybe have seen it. It's a case between German environmental association, Deutsche Umwelthilfe, and Peugeot, because there was a video on YouTube channel of Peugeot, which was only 15 seconds, as I said, entitled Peugeot RCZ Experience the Boxer, and basically it was advertising a new car. But it was more a little, using this idea of the Boxer, doing a bit of training, and there was the letters, the key letters, the R, which is in the R experience of this car, was quite highlighted, okay? And only at the beginning and at the end, there was an actual image of Peugeot and the car, and in between there was 15 seconds of box training. And they brought an action in Germany claiming that the video did not provide any information on the fuel consumption of that car or the carbon dioxide emissions. And that would be an infringement of a very lengthy German law, which basically says there is an obligation to inform about certain key data of cars when you advertise them. Now you could ask yourself, what does that do with AVMS, and especially what does it have to do with the Court of Justice? Well, I will tell you. The question is that any type of promotional literature, and literature is not supposed to be understood as printed documents, but any type of advertising basically you do in promoting a new car has to, and both when a company that produces the car uses it as well as car dealers, has to provide users with the basic information concerning this fuel consumption and emissions. But there is a slight exclusion, and that is very relevant for us, as long as it is not audiovisual media services under the meaning of the directive. And the Court of Justice had to decide it because the German court, thankfully, that was dealing with this, realized, oh, there might be an issue here about the scope of the AVMSD, because although there is an EU directive which obliges Germany to have this rule on informing users about the fuel consumption, there is a recommendation of the Commission on applying this provision, and it says, be careful, member states, when you implement this law, don't make it applicable to television in those days, or now audiovisual media services, because that's a separate regime. There is a separate regime for advertising. And in other words, if somebody has a YouTube channel where there is very short advertising videos, does it fall under the AVMS? Do they operate in audiovisual media service? In which case, this information obligation does not apply, or is it not? Then there would be this information obligation. So it's the first new decision on the scope of the AVMSD after the New Media Online case, which I talked about last year. And the Court of Justice, in a really, really, really short decision, the decision is only 5 pages long, and if you delete all the parts which are only explanation of the procedure, and if you delete all the parts which are quotations of the law, you have about 15 lines left, honestly, and came to the conclusion it's no AVMS. And they did so for both elements. They said it's not an audiovisual media service in terms of the classical definition under litera I, the idea of being a program in the sense of informing, entertaining, educating the general public. They refer to recital 22, because they said it's not that. It's clear that this video only wants to promote, only for commercial purposes, to advertise the car. And even if a promotional video has the potential to inform people, even to entertain, you know, this boxing thing, or to educate viewers about what is so great about the car, it does so with the sole aim of promoting it, not neutrally informing people. And that's why it cannot be a program. But then the second question is it maybe an audiovisual commercial communication according to the definition of the AVMS? And there it has to be, in order to be an AVMS commercial communication, it has to be integrated as an element in a continuing program. So it has to be indeed something that promotes goods, services, or whatever, but within a catalog or a program. And again, the Court of Justice analyzed this and said, if a video channel of Peugeot has nothing else but short video clips about its products, in that case cars, then it cannot be regarded as being integrated somehow in an overarching program. It is not relevant under AVMSD. And what is interesting is Peugeot had argued, yes, but at the beginning and at the end, as I mentioned, we've got these images of the car, and in the middle, that's the program. So basically, the program is interrupted by the actual ad at the beginning and the end. I must say, in a 15-second clip, that's maybe not the strongest of all arguments, and that's why the case, unsurprisingly, was not, for me, unsurprisingly, was not successful. But before we look at what comes next, I do have a question to put forward, and that is, what about if it's a 5-minute video clip? What about if it's a story of somebody, and somewhere in the middle of it, somebody gets into a car, and it's not even mentioned which car it is, more about the feel and look of the car, and it's in order to get the people interested. What could that be for a car? There's no mention at all of which producer, which manufacturer, which car. And then there might be even a series of such videos, you know, 1 year before the launch of the car. Every month a new video, and you make a story about it. You have a main character. And let's even say it's a 15-minute video. That is not completely unheard of. Is that then still so clear as it is with a 15-second clip? I don't know. Therefore, whether that judgment really stands the test of time, I'm doubtful. Some comment on it and say, just forget about it. Act as if you never heard that case. I wouldn't go as far as that, because it does say something about the scope of the AVMSD, but it is not clarifying the whole YouTube advertising context, to put it in clear terms. Well, what else do we have? Let's see what's next, because that's one of the lines you find on Netflix webpage. See what's next. There's a case that Netflix lost before the General Court a very few days ago in May. And it was about the film fund law in Germany that had been amended in the sense that not only traditional broadcasters that transmit movies, films in their more than 1 hour length in their programs have to pay a certain levy. That was extended also to video on demand providers originally, and then in 2014 it was expanded to video on demand providers that are established outside of Germany if they disseminate it in Germany. So it may ring a bell about country of origin, but we're not talking about the AVMS here, we're talking simply about a law which has been introduced for cultural support. And to be also honest, it doesn't only put on the obligation to pay the levy. If you are under that obligation as a on-demand service provider, you can also get aid. So if you produce, for example, a movie as Netflix and you fall under that law, you can also ask for support from that film fund. And it's basically a state aid measure, because there is this possibility of asking for money, and also the income for this fund comes from the broadcasters and video on demand providers that can profit from it. And that's why the Commission had to be asked, can we do that? The Commission looked at the law and they said, yes, this is okay under state aid law. Netflix was not happy, because they are not established in Germany, they're established in the Netherlands, and they have a very big German audience, and they said, we don't want to pay for that because we're not established in Germany. And they they contested the decision on very many grounds. It's quite an interesting variation of legal arguments that are provided. For example, they said, actually, the Audiovisual Media Services Directive was violated by this law, because the country of origin principle just doesn't allow expanding such an obligation into foreign territory. And what is very remarkable is that the lawyers argued that because there was already the proposal on the table by the Commission for the new Audiovisual Media Services Directive, which did not foresee such levies originally, it is not possible to judge the current law without taking that into consideration. Now, that's not exactly the methodology that you should apply, and that's why the court also ignored it, because it's just a proposed amendment, and as we know since yesterday, it has changed significantly between the proposal and what has now been agreed on. And yes, there will be such instruments in there, and that's why it was right that the court didn't even enter into this discussion. But they also said it's a problem on the competition law. In Article 110, there's something about a non-discriminatory rule, and they argued it's basically a Lex Netflix. It is basically directed at us and no one else. They also said the Commission, when it analyzed the state aid program, didn't take into consideration the primary law, such as the freedom to provide services. And finally, they said, using the cultural objective exception, so that's the idea, state aid can be justified if it is supporting certain goals, for example, cultural grounds, Articles 107, paragraph 3D, and the Commission allowed it on that basis, and they said that's wrong, because it's not reaching that goal. And the answer of the General Court, and this I really regret, but it didn't have much chance really to do it differently maybe, is very simple. The whole procedure is inadmissible. Netflix hasn't demonstrated that this is a matter that affects it in a way which distinguishes it completely from all other providers. And that's what you need. You need an individual targeting to make it relevant for an EU law decision. And then they said, you didn't even wait to be taxed or to be asked to pay these levies on the basis of the law. So if you would have done that, you could have gone to a German court and you could have asked a German court to interpret that. And maybe then the German court would have asked in a preliminary reference, not the general court, but the Court of Justice, to decide about that. But you as an individual, Netflix, have no standing before the general court, and that's the end of the story. So we don't have any substantive decision at all in that case. And that is interesting for the following reason. There is a second one pending, which is not from Netflix, but it's from Apple. It is basically the same story. Apple didn't like that either. That's why they're very unhappy on this picture. And they said the same thing. Country of origin doesn't allow something like this. There is a specific provision in the AVMS about European works. That should be implied. It shouldn't be the German national law that decides about that. 110, the primary law. And they only have one additional argument, and that is the law should have been notified under the so-called TRIS directive, Technical Regulation Information System, to the Commission in advance of it being passed. Why? Because it targets specifically so-called information society services. And if that's the case, then it has to be pre-notified, which was not the case. And if the court would see that as a problem, then that alone could actually lead to a formal inadmissibility of the law. But my guess is, if they decided Netflix a few days ago in the way they did, it's also going to find a way to declare this inadmissible, so we will not have a ruling on this, which means, in other words, we have to wait for the transposition of the AVMSD, the new one, once it's been formally published, and then maybe have a German or any other national law adapted in light of the levy provision against providers that target a certain market, and then that will go to the Court of Justice, and then we will know whether it is possible or not. I wouldn't be surprised if it is possible, and I wouldn't be surprised if it takes at least 5 years until we know. IP law. There is one or two things I want to point out to you in IP law very, very quickly, because they are not so relevant for us, but a little bit. There is this VCAST decision of last November, where basically there was an online recorder that you could use. There was like an online service that if you missed looking at something on a broadcast channel, you could go to that website and that basically recorded privately for you in a cloud. And the question was, is that just a private copy that you're doing of a recording? Because you could have recorded with your old VHS or your hard disk the program directly. But it's not you doing it, it's that online service you're using, VCAST. Are they allowed to do it, yes or no? And the court says that that is not a private copy exemption because it's a different company that's using that, and they did not have a license to do so. It is a violation, or at least it is not covered by the private copy exception. So in principle, it's a violation if you have not cleared that. Business model, cloud recording, not good. And that is in a way a logic continuation of the ITV broadcasting cases which had been decided earlier. Another one is not yet ready, but the Advocate General gave his opinion at the end of April. That's a very interesting one, because if you were puzzled about what the communication to the public means already until now, with all the cases that I presented last year and over the last 5 years, this is a real interesting one. Now, until now, the court has been relatively, let's say, strict, more or less. If it's not clear what you put online, or whether you make available online by, for example, putting links to hidden websites where there is something illegal online, it's usually a communication to the public. I'm simplifying a little bit. But here there was a case where a school had published on its website the work of a pupil that clearly contained a photo without credits. And that was not a photo that the pupil had made. Actually, the pupil had found it on a different website, on a travel website, downloaded it, and it's online now and it's freely disseminated. And so the owner of the original photograph wanted to say this is an illegal communication to the public. And the Advocate General is suggesting, we don't know yet whether that will go through like that, but is suggesting to say it's not a problem. Because on the original page, it didn't say that there was a restriction to use the photo. Okay, so normally it's the assumption you have to find out what is happening. And I think personally it is because of the specific context. A schoolwork on a freely accessible website, clearly no commercial purpose. It's, you know, somebody did their paperwork and on the front they put this picture. But you could argue and say, well, does it mean if you're young and naive, basically, you don't have to know the law in the same detail as somebody who has a professional website? So I'm curious to see whether the court will follow this. Probably yes, because every other outcome would be really bizarre. The school would be asked for damages for, I don't know. But it is difficult to argue it under the standards because until now the court has been relatively strict. If there's no clearance and you reproduce something on your own website, you cannot defend yourself with saying, but the photo was already available elsewhere for free. At least you have to somehow credit it. And here they said, because there was no obligation, please only use this photo if you credit it. I think it is quite complex to see how this will develop. I would like to give you also a case on data protection law, which we heard about very much now. That's why I'll keep it brief. On Wednesday, the court decided this ULD, that's the Data Protection Authority of one of the Länder in Germany, case about Facebook fan pages. The case has, in my view, two things. One is, it is about what consequence does it have if you use a fan page on Facebook? In other words, does it make only Facebook the controller of data, or also the one that is using this fan page, in that case the Wirtschaftsakademie Schleswig-Holstein? And the other question is about the authorities' powers, the DPAs. Because the DPA said, not to Facebook, they said to the Academy, you never asked for consent what is happening with this web tracking. That's why you're not allowed to use this Facebook fan page. It's interesting because the Wirtschaftsakademie is more or less, although it's set up as a private company, a state-driven activity. So it was in a way public against public. I would say, after all you heard until now, I would agree, that first part of the decision is not really so valuable on long term, because it's still under the old law and it is without respect of the e-privacy issues. Because the court simply asked, the German court simply asked, under the Data Protection Directive, what's the situation? Yes, but now we've got the GDPR and it doesn't translate one-to-one. But what is interesting is that the DPA's powers were confirmed, that already under the old directive, they could also, even if there is a question about jurisdiction, because Facebook does not have a full seat in Germany, can still get involved in that case because Facebook has a subsidiary that takes care of the advertising in Germany. So that's in a way also a continuation of what was said in Google Spain. For now, indeed, the admin of a fan page outside of Facebook, so of the one that uses the fan page, is also a controller and is a kind of a co-controller with Facebook. And the DPA can choose whether it goes against Facebook or whether it goes against the admin. But what that means exactly, whether it's really now advisable to shut down all Facebook fan pages, I would be a little bit doubtful, because the extent to which you have to know how much data is collected is not clear from that decision. What you should do, however, is if you have such a page, is certainly try and find out what does Facebook do if you install a fan page. At least try and find out, and if you can find out, then put it on your website and say, by the way, we're using Facebook fan page, which means these and these data are being collected. Okay, what's coming from Luxembourg? Again, Facebook. Facebook is ensuring jobs for all the referendairs at the Court of Justice. No, but it's obvious that that's a very important time. The reason why I'm pointing out this case is because it doesn't have anything to do with data protection, but with the e-commerce directive. So it's even more relevant for media companies. What obligations do service providers have that allow users to create content and disseminate it? In that case, it's an Austrian politician, ex-politician, Glavižnik Piszczek, and she was basically defamed on Facebook, and she requested that the posts were taken down, but not only taken down in Austria, but taken down everywhere, so that that post would not be available anywhere in the world. And in addition, any post which has a similar content, I'm going to not repeat the exact words that were used against it. They were very negative, and they were insulting, defamatory. And she basically said, anything that is like that or similar, please take it down. And the question indeed that has been posed in January to the Court of Justice is, can a national law allow such an obligation to be put on a provider, a host provider, to remove illegal content in such an extent? So not only one targeted message, but that message, no matter from where it is accessed, and anything that is not identically worded, but similar, equivalent in meaning. Let's see. That's going to be an extremely important decision, because the e-commerce revision, as we heard, will take a while. So we still live with the liability regime of the e-commerce directive, Article 12 to 15. And this is the potential to clarify what no general monitoring means, which is prohibited, by the e-commerce directive. But it says something about duty of care standards, and the Austrian law basically uses it and says it's the duty of care of the providers to make sure that if something like that happens, they also, don't only delete the one message or take it down, but they kind of make sure that the defamed person is protected in a more broad sense. Let's see what comes out of that. At least a year to go until we have the Advocate General's opinion and the decision, so I guess end of next year, maybe if we're lucky at the next conference. Our probably by now well-known fellow lawyer Max Schrems has been already confronting the Court of Justice with several cases. The most famous one is Schrems, which I call now number one, the one that struck down the safe harbor decision. But Schrems III, and I will explain in a moment why it's number 3, is forthcoming, because the Irish High Court in commercial matters has just handed over the questions in a new preliminary reference procedure, which concern, again, Facebook's transfer of data from Ireland to the US, but no more under the safe harbor decision. Obviously, that's gone. But in this case, under standard contractual clauses. It's a very lengthy decision. Actually, if you want to be, if you're interested, read. I'm referring to that in the link. Read the original referring decisions, about 50 pages long, of the Irish High Court, and it very clearly explains already why they asked these questions. And then there's a number of questions, nearly a dozen. And the one that is most important maybe is very simply that says, if we do not use any more safe harbor, but if they use a standard contractual clause, does that violate Article 7 and 8? And then there's very more detailed questions about what that means exactly. If the court answers similarly, as it did in the first case, then it means we again have one possibility less for companies to use international data transfers. And then the third question will obviously be, and most likely it will be implicitly answered by this case as well, is the privacy shield a sufficient replacement of the safe harbor, yes or no? So definitely look out for that. Since a couple of days we have the case number, which is 31118, but it's not even published yet in the official journal, the questions, so you have to look at the National Court. There's also more Schremses coming. I want to have a trademark on that now, the Schremses. Why? Because as we heard yesterday, Max Schrems created a non-governmental organization, NOIP. I told him I didn't think it's a great name in the sense of you don't immediately know what it means. It means none of your business. Okay, so no YB. On the day of the applicability of the GDPR, filed very similar complaints, but at different data protection authorities, you can see there, against Google, Instagram, WhatsApp, and Facebook, on what they called forced consent. Basically, the privacy policies have been changed, but it's still, in the view of the of NOIP, take these policies or you're not in. And the GDPR actually requires that you have the possibility to accept to certain things for certain services, but not one or nothing. Don't be afraid about these billion euro fine pay. This is a screenshot from NOIP, the webpage. They just wanted to illustrate they made a calculation if the highest possible fine would be imposed if the cases were decided in their favor. It could go right up to there. The CNIL has a case, the Belgian DPA has a case because they've anyway already been investigating also against Facebook, so they put Instagram there. In Hamburg and in Austria, one has been delivered. Why do I say this might be Schrems IV? Because the EDPB, the European Data Protection Board, in its very first meeting on the 25th of May, didn't only pass, as we heard this morning, or reiterate its old guidelines, that they also are valid under the new system, but they also already discussed first cases. And on the first meeting after, which was last week, they already talked about whether these cases might be of relevance to be decided at the board level because they concern so many markets. It's not a matter actually for Austria to discuss about Facebook. It's a matter for all of them. So they've already been discussing it. And my guess would be if the outcome is not that there will be a fine against these companies, or sorry, a sanction, not necessarily a fine, it'll go to court. If it goes to court, the courts will say, Luxembourg can decide this. It's not going to be me in Austria or me in Germany. Luxembourg can decide it, so Court of Justice. It'll take a while, but we'll have more to come. Why number 4? Just as a reminder, I'm not going to go into the case. You can read about it if you want to in my presentation. Schrems II, at least in my numbering, Schrems II is the class action case which was handed down this January. Also very interesting, but it was a question about whether he can represent many other data subjects in a case against Facebook, or whether not. The Austrian law would allow that, and the question was whether under EU law that should be allowed, and basically he lost that case in the sense there is, under the current EU law, no class action, but at least the court didn't go as far as was suggested that because Max Schrems is so active in data protection, he's no more a private individual. That was the argument of the Austrian courts. They said, you're making your money now by being an activist. You're publishing books, you go and give speeches. You cannot claim anymore that you're a normal consumer, and that's why you are not under the Austrian consumer protection law, which allows this class action. And the hope of the referral was that the Court of Justice might say, doesn't matter about the Austrian law, EU law allows a class action. They didn't go as far as that, but they said you can still be regarded as a consumer. And if that's the case, well, basically then he just has to go back to the Austrian courts and say, now I want to have a class action. But they don't need that anymore because under the GDPR, it is possible to do that. Okay. Google is also in the focus of the court, not yet decided, but Google has 2 CNIL cases, so 2 data protection cases from France that have been brought forward. One concerns the obligation or the extent of the obligation to erase data by search engine operators. So you can guess this is the continuation of the Google Spain saga, where it all started in 2014. The question, both in the case GC and others against CNIL, as well as in Google against CNIL, they both basically cut down to the question, how much is the obligation of the right to be forgotten, or more precise, the right to be delisted? How far does that go? One is, the second one, the question of Google. It's okay, we do that. We are implementing Google Spain decision since years, but always only in the market that is concerned. And the CNIL says, if there is a delisting request, you have to delist at least EU-wide or even globally. And the other one is, how far does the extent of the obligation reach to take down? Both have only just been handed in last year, and we do not have any hearing dates or anything yet, so still a while to go, but keep lookout for these cases. I would just like to highlight, because it was mentioned briefly in the presentations this morning, that we have one area of data protection law which is very relevant also for the media, because it concerns the retention of data. So for companies which also store data or might be under a storage obligation. I will not go into the depth of that. It's basically the Tele 2 and Digital Rights Island continuation. But there is a very interesting case of Ministerio Fiscal, which the Advocate General recently gave its opinion. That has something to do, as you can see, with normal criminals. And there is an agreement that data retention rules might be applicable and possible for combating serious crimes. And the question is, what about if somebody just robs a wallet and a mobile phone, which is certainly not a serious crime, is under certain conditions it at least possible to access data which has been retained. So the case is not about the question, could the data originally be retained, but if it has been retained, do law enforcement authorities or the police, can they be granted access to that? And interestingly enough, the Advocate General proposes, and I'm not sure whether the court will follow on that, that even minor criminal offenses, or he says not particularly serious offenses, can justify electronic communications metadata to be given to the police, as long as that disclosure does not result in a serious infringement of the right to privacy. So giving out, a little bit of data about somebody might not be so bad, so it can even happen if the crime was not so bad. I'm not sure whether that is a category that can work, but it's interesting to look out for it. Only just came a few weeks ago, so by the end of the year we should have a decision on that. I could go into the details of many more, but I will only highlight them here.
Only 2-3 minutes?
I will only highlight them because of the time limitation, and then I will give you one ECtHR case. One is Spiegel Online against Volker Beck and Funke Medien. It's by pure coincidence both from Germany. It's about how IP rights can come into conflict with access to information. One of them is about the press publisher's right in a variation. That's a Spiegel Online case, which we do not have yet, the press publisher's right. And the second one is what I call the Afghanistan Papers case. You probably all know the Pentagon Papers case. It's about whether a government can refuse access to what they declare as classified information, not based on the classification or secrecy, but basically saying we have the copyright on it. The data about our military is copyrighted by us, so we're not going to give it to you. We don't have to. And another one that concerns must carry obligations, so infrastructure again is France Télévisions, and that goes against Play Media and the French authority about the question of whether a certain provider is to be regarded as an electronic communications network, and in which case it would have an obligation to follow Article 31, Universal Services Directive must carry obligations. Another one that I just mentioned because time has already played beyond it, that is a case about cookies and opt-out. So you remember that in a GDPR you now need an opt-in and active, and you're not allowed to say we've already ticked the box, you have to opt out. That case came to the court in November 17, and one of the preliminary reference questions is, how is this situation under the GDPR? Although the GDPR was not applicable then yet. Maybe the court will just ignore that question because it was inadmissible in a way, or the court will take the opportunity and say, great, we can already now say something about the interpretation of the GDPR. And it's about the whole question we had this morning about cookies. Last one to highlight, because that was in your presentation briefly in. Canal Plus is going against the Commission for saying you completely misunderstood in the assessment of the film bundle competition law assessment what impact these decisions have on culture, the film financing. So there is a reason why there are territorial restrictions in order to get out more money to be able to produce more films. That's been pending since quite a time, but there's nothing decided yet, and I'm wondering how long it will take. I will finish off with one case from Strasbourg, and that is the SATA Media case. I will mention the SATA Media case for the following reason. The Finnish Data Protection Board went against two media companies that did the following. They published on the website routinely tax data. You have to know that in Finland and Sweden and elsewhere, the tax data of the citizens is more or less public. So there are websites where you can find it, and they did that. They harvested it, and then they put it on their own website. And then you basically would search for a person and say, I want to know what their tax is, their income, and what they pay for tax. They've been doing that for a long time, and suddenly the Data Protection Authority said, you can't do that because it's private data. And they went to the Court of Human Rights, and the Court of Human Rights in Strasbourg said, there is a derogation in the logic of data protection law that says journalistic purposes can supersede the protection of private data because it is relevant to allow journalists to have access to data, to perform their journalistic activities. And these are very important in a democratic society. But access to public documents or access to documents also by journalists does not in itself justify that you disseminate this data in a raw form without reporting. So for example, if they take the data and say, it is very interesting to see that our prime minister earns 50 million euros from a sidekick, maybe that makes him dependent on something, that they could do. But if they just say, we repeatedly take the data and put it on our website, that might not be protected by Article 10. And indeed, they said it's not a violation. And the big question is, what impact will this have on what we call data journalism? A lot of journalism today is just data-driven. Journalists collect data and then make it available to the public. Maybe they sort it, maybe they categorize it a little bit, but not necessarily with an article. And you know that in the GDPR, we have the media privilege article, which says every member state has to ensure that there is a balancing made between freedom of expression, freedom of the media, and the protection under the GDPR. And most member states have come up with a solution which is pro Article 10, basically, pro freedom of expression. But there will be cases coming up in light of this decision. I will skip the rest and give you just one idea. If you want to know more, apart from looking at the full presentation, where can you look out for especially pending rulings? One is on our own website. We try to always give a brief summary if there's an important decision taken. And there is a website, although it's in German, by a colleague in Austria. That's excellent. It's not in English, but it doesn't matter, because what he basically does, he lists all cases, whether they've been decided or whether they're pending. So even if you don't understand what they are exactly about, because it's in German, you have the case numbers, and the case numbers are the same for all. And then another place that you can look out for is the European Audiovisual Observatory. There is like a monthly newsletter with all important decisions by the Court of Human Rights and the CJEU. And that is in English, French, and German. So there it's more easy. And there is a big book which comes out once a year, which is called Freedom of Expression, Media and Journalists, which on one page per case summarizes all Article 10 cases by an excellent scholar, Dirk Vorhoff, and it's free. It's free, and you can very easily use that, so you should do that. And the last possibility is, well, and that's my closing word, just come again, and I see you in 2019. Thanks a lot.